Maybe you missed this, or with all the news that's been happening the last month, you just forgot about it. But the Supreme Court has handed down one of the most consequential decisions in American history. And even a statement like that doesn't really narrow down what I'm talking about. Since 1984, the regulatory framework of the United States has been built around a concept known as the Chevron deference. At its simplest, Chevron deference, also known as the Chevron doctrine, is a matter of who gets to decide what should be done when a statute is ambiguous. Is it a regulatory agency, or is it the courts? Where you fall in the answer to that question will depend on who you think should be making decisions. Should it be experts on the law or experts on the matter governed by the law? For the last 40 years, agencies have held that deference. All in all, over 70 Supreme Court decisions have relied on the Chevron deference, and more than 17,000 lower court decisions have relied on Chevron. That is, until June 28th, 2024. In a 6-3 ruling in the case Loper-Bright Enterprises versus Raimundo and Corner Post Inc. versus Board of Governors of the Federal Reserve System, the Supreme Court decided that from now on, courts, not agencies, are going to decide how to interpret the ambiguous or open areas of statutes. The reactions to the case were quick to come in. One side of the aisle called it a huge victory for the separation of powers and a blow to the Washington bureaucracy that's been pulling a fast one on congressional intent for 40 years. The other side calls it a Supreme Court power grab that will cause untold chaos and harm to the health and safety of the American people. So why is this decision so consequential? How did we get here? That's what we'll be looking at on this episode of 312, the HRP Podcast. We're dedicating this episode to the decision because helping our clients navigate regulation is what we do. We are deeply embedded in these issues, and the potential consequences of this ruling could be truly massive. First, we have to go back. It's June 25th, 1984. Ronald Reagan is president. Duran Duran's The Reflex is topping the music charts. Gas costs $1.20 a gallon, and a film called Ghostbusters is absolutely blowing up the summer box office. Meanwhile, the Supreme Court is about to accidentally make history, and it's all because of bubbles. Case before the court is Chevron USA versus National Resources Defense Council.
Gentlemen, the case is submitted. We'll hear arguments next in Chevron against Natural Resources Council.
That's Justice Warren Berger at the opening of oral arguments for the case. The issue at hand was how and when EPA could require permits when it came to pollution-emitting modifications. EPA made a ruling that states could allow the addition or modification of pollution-emitting devices in the same plant into a single bubble. This would allow for installation or modification to one piece of equipment without needing a permit, provided that there was no increase in total emissions. The Natural Resources Defense Council, an environmental group, challenged the bubble provision as contrary to the Clean Air Act. This is where I need to break in and do a little commentary here, because the relevant question at hand is so semantically nitpicky and hyper-specific. To the lawyers out there, I'm sure this is nothing new, but the relevant question in the case was, quote, does the Clean Air Act permit the EPA to define the term stationary source to mean whole industrial plants only, which allows plants to build or modify units within plants without the permit required under the Act? You got that? The EPA's bubble was built on the definition of stationary source, and we're about to find out if the Clean Air Act permitted EPA the latitude to determine that definition.
Columbia held that the bubble definition is unlawful, that the administrator has no discretion in how to define source, that the statute compels one rigid definition. And we are here asking this court to correct that holding and to hold that the regulation and the definition fell within the lawful discretion of the administrator.
That was Paul and Bader arguing for the government. And after all, what was a plant? Once a plant was more than a single building, and certainly more than one piece of equipment or device that emitted pollution.
I think maybe it would be well for me just to say a word about how we think the bubble system works as a matter of the administrative technique that is involved. The point of the bubble system is that for purposes of determining whether this complex of administrative requirement is triggered, you look at the plant as a whole, and that assumes an existing plant. And it's as if the entire plant were encased in a plastic bubble with a single emissions hole at the top. Now, if you have new construction or expansion within that plant that increases net pollution plant-wide more than a de minimis amount, then everybody's agreed that new source review comes into play. But under the bubble approach, within a plant, an individual machine can be added or modified without new source review if additional pollution from that new construction is offset by reductions or elimination of another machine so that there is no significant additional net increase.
If there's no real change in pollution, don't worry about the permit. It's about emissions, right? That's what EPA thought. The issue was that the law hung on having two overlapping definitions of the term source due to later revisions from Congress to the Clean Air Act.
The two uses of the term in the same subparagraph ought to be presumed to have the same meaning. That's the only reasonable conclusion, particularly when you look at the legislative history of subparagraph D. Subparagraph D is the result of Congress's having looked at the new source review procedure that was provided in subparagraph D in the 1970 Act, deciding that it was inadequate, that it did not provide for careful review of new sources, and deciding that it needed to be strengthened by creating the permit program that we find in Section 173. It is not credible to suggest that when Congress amended subparagraph D in 1977 to add to it the permit program for stationary sources, it meant the term stationary sources to mean something new, something different than it already meant in the same subparagraph. Well, having established that the two uses of the term have the same meaning, what is that meaning? Again, as Mr. Justice Stevens has suggested, terms such as building and structure plainly refer to individual industrial units like boilers and blast furnaces, things that actually produce pollution. These terms, we contend, can't reasonably be defined exclusively as entire plants. The 1977 legislative history, moreover, specifically rules out the bubble definition that EPA has adopted. It explicitly bars a new project from escaping the permit review just by obtaining an offset from within the same plant. And I refer you to page 36 of our brief, which quotes the statement of Senator Muskie, who was chairman of the Senate conferees, and he was explaining the meaning of the permit program required by the conference bill to be included in every state plan. And he said, a new source is still subject to such requirements as the lowest achievable emission rate, even if it is used as a replacement for an older facility, resulting in a net reduction from previous emission levels. Now, he was there explicitly referring to the situation where someone takes a facility in a plant, retires it, and replaces it with a new one, a new boiler or blast furnace. And he said, you're still subject to permit review. You cannot net out of the permit review simply by getting an offset. Now, the reasons why Congress was not satisfied with just an offset that keeps the pollution from increasing are plain in the requirements and purposes of Section 173. In enacting that section, Congress made it clear that it wasn't enough just to keep pollution from increasing. First, pollution had to be made to decrease. The offset that's required in Section 173(1) is an offset which is more than equal to the pollution that the new boiler is going to add. The pollution overall has to be reduced.
That was David Doniger arguing for the Natural Resources Defense Council. Doniger goes on to argue about how we consider something a source. That is, it has to do with amounts, and the bubble concept essentially lets you put what should be multiple sources into a bubble that treats them as one source. Both sides make an argument that the other doesn't understand the intention of the statute. Did Congress want to balance multiple impracticalities with the statute, or did it want to maximize pollution reduction wherever it could? Ultimately, the court unanimously decides with the EPA, saying that the interpretation of stationary source was a reasonable understanding of what was in the Clean Air Act, and that Congress had not spoken to the specific issue at hand. In fact, the multiple possible definitions, rather than creating contradiction, should be seen as intending to enlarge EPA's discretion. Here's where the meat of the Chevron deference comes in. The Supreme Court says when Congress does not explicitly state its intent, agencies are necessarily permitted to fill the gaps and resolve the ambiguities. The court saw agencies like the EPA not as contrary actors, but as organs of Congress's intent, a means by which Congress would achieve the goals set forth in its legislation. Congress can in fact delegate authority to the agencies by leaving deliberate ambiguities, and that the court may not substitute its own construction of a statutory provision over a reasonable interpretation of an administrator. Basically, the court can't make up its own definition of an ambiguous statute, if the agency's definition can be argued as a reasonable interpretation of what the law allows. Critics will no doubt mention that the source of this idea doesn't seem to come from Congress, but rather is mysteriously located by the court. So how does this play out? Quote, the court did not at first treat Chevron as the watershed decision it was fated to become. It was hardly cited in cases involving statutory questions of agency authority. But within a few years, both this court and the courts of appeals were routinely invoking its two-step framework as the governing standard in such cases. As the court did so, it revisited the doctrine's justifications. Eventually, the court decided that Chevron rested on a presumption that Congress, when it left ambiguity in a statute, meant for implementation by an agency, understood that the ambiguity would be resolved first and foremost by the agency, and desired the agency, rather than the courts, to possess whatever degree of discretion the ambiguity allows. A little Chevron history lesson there for you, courtesy of Chief Justice John Roberts. And for the next 40 years, this deference will decide the outcomes of thousands of cases. It's night on the Atlantic, and in the cold, shallow waters, the ocean is glowing. Bioluminescent plankton are lighting up the sea in an attempt to confuse and surprise the nearby school of Atlantic herring. Consider the herring, a small but long fish found in cold, shallow water with an oily and rich taste. The herring has been a staple of the human diet for more than 5,000 years, from ancient fishermen to the commercial fishing industry of today. This fish, and those who fish them, are the trigger for the case that will overturn the Chevron deference. In order to ensure conservation measures around the herring fishing industry, monitors were placed on fishing vessels. And the cost of those monitors was being paid by the fishing industry, with limitations on how much the cost could be. Said cost must be limited to 2 to 3% of the value of what the vessels were catching. It should be noted that these fisheries were a larger application of law written in reference to different fisheries. Now, while that is at issue, the main problem is that the cost to the vessels in the herring fishery was far in excess of that 2 to 3%, with figures cited at 20%. And while this issue is what launches the case, by the time we reach the Supreme Court, it's very clear that the issue to be decided is the Chevron deference, which lower courts have been applying in the case thus far. The argument made against Chevron is about separation of powers, that one branch of government interprets, the other implements, and the two cannot cross paths.
But so that's the difference, I think, the fundamental difference from a separation of powers standpoint between a limitation on remedies, where Congress does it specifically, and essentially telling the courts in the APA specifically, you have the interpretive authority over statutes no less than constitutional issues, but then overlaying a doctrine that says what we're doing is interpretation. And that's the critical thing about the interchange between footnote 9 and footnote 11. Footnote 9 tells you as clearly as you can what you're doing in a Chevron case is statutory interpretation. But then in footnote 11, it says at a certain point, you stop doing statutory interpretation, even though you think there's a better answer, and you defer to a different branch of government. And it's not the branch of government the framers gave the interpretive authority to. It's the branch of government that the framers gave the implementing authority. So I think from that standpoint, Chevron is a fundamental, egregiously wrong decision that just gets it wrong on basic separation of powers.
That was Mr. Paul Clement arguing against Chevron. Here's another quick clip of Mr. Clement.
Methodology, which is entitled to reduced stare decisis effect. We have no beef with Chevron's Clean Air Act holding, and we could not take issue with its APA holding because it failed to mention that statute. But second, all the traditional stare decisis factors point in favor of overruling Chevron's methodology.
I just wanted to play that for you because I think hearing the term "we have no beef" in oral arguments at the Supreme Court really helps us understand that we are in a very different cultural moment from the 84 oral arguments. And Justice Sotomayor was, to say the least, skeptical of this argument against delegation.
Everybody seems to concede means discretion. It means there's multiple meanings that you can take from something, and someone has to choose among those meanings. It seems like most people agree if the statute uses reasonable, that Congress is delegating the definition of reasonable to the agency. And the agency is deciding what is reasonable within some outer limit, either set within the statute or within the law. But the point is that it's great rhetoric, Mr. Clement, but we do delegate. We have recognized delegations to agencies from the beginning of the founding of interpretation. And so I'm at a loss to understand where the argument comes from.
Mr. Clement's response came down to a distinction between the discretion agencies have to operate within versus the delegating of congressional authority to a different branch of government. There was an interesting hiccup in the argument, however. Were it the case that the monitors were taking such a cut of the catch so blatantly disproportionate to that established 2 to 3% and in an area not originally authorized, then this isn't a Chevron case.
You're just arguing that the statute's not ambiguous on that question.
I am arguing that the best reading of the statute is that my client wins.
That's Chief Justice Roberts reminding everyone that Chevron is 2 steps. First, determine if the issue has been clearly addressed by Congress. If it has, case closed. If not, if it is ambiguous, then the court simply had to decide if the agency's interpretation is reasonable. Can it reasonably be found in the statute? And if so, then the court defers to the agency. So says John Roberts. Well, Mr. Clement simply says that the law says he wins.
We have no beef.
I have to say that knowing how this ruling comes down, it is fascinating to hear Chief Justice Roberts clearly arguing that Chevron is not applicable to the case and getting really no clear answer back.
You were just saying, that the principle of exclusio unius answers the question. And if it answers the question, I guess I don't understand how you even get to the Chevron issue. Because Chevron step 1, you would give the same answer.
Maybe you would, Your Honor, but nobody knows where step 2 ends and step 2 begins. And
we get a quick pivot to the separation of powers issue with the claim that far from delegation to the agencies being a tool of implementation, it's in fact a way to pass laws that would not otherwise make it through.
That is just fictional, and it's fictional in a particular way, which is it assumes that ambiguity is ours a delegation. But ambiguity is not ours a delegation, and more often what ambiguity is, I don't have enough votes in Congress to make it clear, so I'm going to leave it ambiguous. That's how we're going to get over the bicameralism and presentment hurdle, and then we'll give it to my friends in the agency, and they'll take it from here. And that ends up with the phenomenon where we have major problems in society that aren't being solved because instead of actually doing the hard work of legislation, where you have to compromise with the other side at the risk of maybe drawing a primary challenger, you rely on an executive branch friend to do what you want. And it's not hypothetical. When I hear you talk about
Mr. Clement, Chevron basically allows for a kind of corruption that subverts the authority of Congress, or at least it could. Well, Solicitor General Preligar, for the argument of favor in Chevron, the question of delegated authority was treated as largely so.
Throughout this litigation and at times this morning, petitioners have sought to characterize this case as presenting a fundamental question of the separation of powers and a test of Article 3, will courts continue to say what the law is? But I think stepping back, I want to make sure that what doesn't get lost in the shuffle is that petitioners have made an important concession that I think illustrates that the issue here is actually far narrower and that their attacks on Chevron lack merit and are unnecessary. The concession is this: petitioners acknowledge that Congress can expressly delegate to agencies the authority to define statutory terms and fill gaps. Imagine, for example, if the statute said in Chevron, stationary source as defined by the administrator. I take both petitioners to give that up and recognize that is a delegation and courts should respect that. The role of the court in that circumstance is to make sure that the agency has followed the proper procedures and stayed within whatever outer bounds Congress itself has set. And all of that complies with the Constitution, of course, because Congress has Article I authority to delegate gap-filling authority to agencies, and the executive has core Article II authority to fill in those gaps. That's a core exercise of the executive power. And then the Article III courts are just fulfilling their judicial role when they give effect to what Congress has done in its choice to rely on the agency in that regard. But I think what all of this shows is that the constitutional attacks on Chevron and the suggestion that it's egregiously wrong in that regard lack merit, because there is no constitutional distinction between that kind of express delegation and the delegations recognized in Chevron.
There are other areas where such delegations are treated as perfectly acceptable, so when it comes to Chevron, the issue is just, where do you think the line needs to be drawn? Move it over here, push it forward, pull it back. The argument is that whatever you decide, it's got to go somewhere. What's really interesting in the arguments here is that neither side really seems to dispute that the law is clear. It's not in dispute as to what is and is not allowed. Or more importantly, it's quite clear that what Congress was saying with the statute. The lower courts decided that there was ambiguity.
We think that you could find that the statute is clear, but I think that
the fact that you think it's clear and Mr. Clement thinks it's clear, but a court below thought it was ambiguous, should tell us something, shouldn't it?
Mr. Clement is particularly insistent on this point, citing that nearly 60% of cases where the Chevron two-step test is applied find ambiguity, which for the argument raises the question of, are the statutes really that ambiguous? Or is there something more going on here?
There is the most exhaustive survey of over 1,000 cases by Barnett and Walker. We cited on page 33 of the blue brief. It found that courts were reaching step 2 in 70% of the cases. 70% of the cases. The Cato Institute brief, you might think, well, things have gotten better because that was a longitudinal study over a number of years. You might think, well, things are getting a lot better because we've signaled that Chevron is on sort of life support. But the Cato ran the numbers for like 2020 and 2021, and it's down to 60%. But it's still well over half the time your average judge in the Court of Appeals is getting to step 2. And Judge Kethledge, he hasn't updated that speech, but as far as I know, Judge Kethledge still hasn't gotten to step 2 once. And, that's an unsettlement in the law. That's a disconnect in the law that it's very hard to get your fingers around. Like, at least if, one circuit says the statute means X and another circuit says Y, everybody can see that, cert can be granted, this court can resolve the case. But if courts are deciding some cases step 1, some cases step 2 in ways that are radically different, I don't even know how you really unearth that. So I think that's another huge problem with this.
In the end, a 6-3 majority found that Chevron was a violation of the separation of powers and overturned it. The specific violation came from the APA, the Administrative Procedure Act, a law enacted specifically to rein in agency action in the post-World War II era. Quoting from the Loper ruling, "As relevant here, the APA specifies that courts, not agencies, will decide all relevant questions of law arising on review of agency action, even those involving ambiguous laws. It prescribes no deferential standard for courts to employ in answering those legal questions, despite mandating deferential judicial review of agency policymaking and fact-finding." One of the strongest points the majority makes is that Chevron essentially prohibits courts from having an opinion on what the law says. So long as the agency's interpretation of ambiguity is reasonable, it wins the day, regardless of whether the court feels it has a superior alternative version that resolves that ambiguity. And at the end of the day, deciding what the law says is kind of the whole judicial system's deal. Ultimately, the most important point on the decision is that the question is, who is best suited to decide what an ambiguous statute is saying? And the court says, we are, in terms of expertise and as a matter of law. The fundamental basis of thousands upon thousands of rulings was now gone, not to be heard from again. Coming up after the break, maybe it's not that big a deal. For 40 years, the consulting engineers at HRP have worked together with our clients to assure that they move their environment forward. Our job is to minimize the environmental risks associated with our clients' projects and help them reach their intended business goals. Founded in 1982 to serve the environmental needs of the regulated community, HRP is a multidisciplinary environmental and engineering consulting firm. Not only do we provide critical services to clients throughout the U.S., we've also extended our global consulting services to over 20 countries throughout the Americas, Europe, and Asia. Go to hrpassociates.com to contact us today. So what are the consequences? Maybe less than it seems? The Supreme Court majority ruled that despite overturning the Chevron deference, cases decided by Chevron would remain in place. The Chief Justice, on behalf of the majority, writes, "The holdings of those cases that specify agency actions are lawful, including the Clean Air Act holding of Chevron itself, are still subject to statutory stare decisis despite the court's change in interpretive methodology. Mere reliance on Chevron cannot constitute a special justification for overruling such a holding." Stare decisis, in simplest terms, is the respect for precedent expressed as a legal doctrine. The Chief Justice here is saying you can't overrule those prior decisions just because they relied on Chevron. So, if you're worried about your favorite regulatory legislation disappearing, don't worry, it's not going anywhere. At least not right now. Ask me again tomorrow. What's more, zombies. Since 2016, Chevron has been considered by many to be a zombie precedent, a doctrine that, while still on the books, had not been applied by the Supreme Court in 8 years. The change in the makeup of the court may have changed this, may have resurrected Chevron, but Chevron was effectively dead already. So when we look to see where this ruling will have its greatest impact, it has to be on the regulatory legislation on the horizon. Which of course brings us to our old friend, where all roads lead, PFAS. PFAS, the forever chemical, the emerging contaminant, with the potential legal liability of unprecedented scope, is just now entering the first steps of comprehensive federal regulation. We've talked about it on this podcast, on our other podcast, the PFAS Pulse. We've seen EPA rules set for drinking water and proposed bans on PFAS in foods and manufactured goods. We've also seen companies proclaiming that their entire business is dead in the water if they can't use PFAS. Just this year, the EPA added 2 PFAS chemicals to the hazardous substance list. But of those thousands of comments received on the rule, many objected to the lack of statutory definition for the term substantial danger, an essential component of the hazardous substances definition. The future of PFAS regulation is looking far more uncertain now. But whatever does happen, you can be sure it'll end up in the courts. How exactly it plays out in the courts and legislatures and agencies themselves will be played out for years and years and years to come. Everybody, welcome to Play Hard, the video section of the podcast, where you will get to see our faces and hear us speculate on the potential future of regulation and statutes now in the post-Chevron era. I am not a lawyer. I also go by Tom Simmons, Senior Content Creator here at HRP.
I am Dan Titus, CEO at HRP, also not a lawyer.
Definitely no lawyers here.
Very, very, very good at speculative opinion.
Yes. So one of the things that struck me talking to people about what their maybe concerns are, worries about Chevron being overturned, is that it's just kind of like we're going to lose this scientific expertise, and those decisions aren't going to be based on that anymore. But one of the things that I looked at in kind of researching this was that, or when you think about it, it's like, who's actually making those administrative decisions, because it's a bit of a naive assumption that the administrators of agencies are always going to be these good faith actors making expert scientific decisions. When I think anybody who's kind of paid attention to these issues over the years and seen agencies change from one administration to another can name an administrator head who, in their opinion, is a crony, flunky, unqualified, inept moron who should not be in place, no matter what side of the aisle you fall on.
Yeah. There's an old saying, and I'm not saying that it has any truth to it, but it is an old saying. People used to say, those who can't teach and those who can't teach regulate. Like, that's out there. That's been around as long as I've been, involved in this kind of a business, which is 27 years. Oh my God. So yeah, that sentiment exists for sure. I don't think it's universally true, but there's truth in all things.
Yeah. 2 points that we made finishing up the work hard section that I think are really pertinent to the future of this were that for the last 8 years, the Chevron doctrine has been, or in essence has been, a zombie doctrine.
Yeah.
Since the Supreme Court has not been applying it.
Yeah.
Pretty much since the conservative majority took over.
Yeah.
So we've kind of been living in a post-Chevron world for the last 8 years as it is.
That's how I understand it. Yeah.
Yeah. And the other area where, this is more about future regulation statutes, I think, than anything that's going backwards, because as the decision says, they're not overturning anything that was previously decided by Chevron. So I'm thinking that probably PFAS is going to be where we're going to see this really come forward, if it comes forward at all.
I don't know.
You don't think so?
I kind of don't.
Mm-hmm.
Even just stepping aside from the legality or the legal arguments here, such as they are, or, just the doctrine in general, the array of people that are involved in determining that something is bad for you, right? I don't pick whatever space in the public domain you want, whether it's, the FDA or your doctor or exercise scientists or, the EPA. It's not just like there's one individual or one entity that's making this kind of a determination, that, for example, PFAS is a carcinogen, right? There's like, the way that they determine, for example, that maybe lead is a carcinogen, and I'm not even sure that it is, but trichloroethylene, which is a solvent, is a carcinogen. The process that they use for making that determination, I think, is the same, or at least very similar, scientifically speaking, this sort of rigorous step-by-step process where they do, data evaluation and experimentation to sort of try to figure out whether or not something is a particular kind of carcinogen. And I don't know how you, once that determination's been made, I'm not sure how you put that genie back in the bottle. So if you took, for example, asbestos, right? So everybody is aware that asbestos is bad for you, and it causes cancer, lung cancer in particular. So that became regulated as a carcinogen and banned here in the United States a long time ago. Even though we still find it, and we're still trying to get it out of buildings and so on and so forth, because on the one hand, it was an amazingly useful material. It just turned out it wasn't really great for you. But if you look at the risk science, behind them establishing that asbestos was a carcinogen, there was a processing facility somewhere up in Canada. I'm kind of pulling this out of a very creaky old memory here, but up in Canada, where they were mining it out of the ground. A lot of people don't realize asbestos is a mineral that comes out of the ground. Where they were mining it out of the ground and processing it in this plant. And in this plant, you could walk in, and apparently it was just like walking into a cloud because there was so much asbestos in the air. And half the people that worked there were smokers or more. And half of those people got lung cancer. And that's really awful, and it sounds really terrible. But the point I'm making is that, that's the extreme exposure scenario. And even in that instance, only 1 out of 2 people in that exposure scenario got cancer. So, it's not like a 1-to-1 kind of relationship. But once it's been established that it is in fact carcinogen and that some people will get cancer for it, I don't see how you could put that genie back into the bottle. Like with asbestos, it's bad for you, and so it needs to be dealt with. I think PFAS kind of is going to end up in the same place. And I just, regardless of the Chevron doctrine or otherwise, I just don't really see how that goes backwards. We're going to sort of decide based upon, I don't know what administration happens to sit in the White House that something that was bad for you is now okay for you, but might be bad for you again in the future.
And regardless of what even is happening legally in the States, companies are still going to want to do business in Europe.
Yeah, exactly.
Or you're going to have to figure out those regulations too.
Yeah. I just don't see it working that way.
Okay.
I think what I would encourage people to do, even if you're not a lawyer, is actually read the Chevron opinion. Because, when it first came out, I was also like, oh, Jesus, here we go. Like this is going to be a huge problem. Yeah. And, there's all the talking heads in the news media. I think, unfortunately, a lot of news media has become really just sort of headline driven. And maybe even more so than it ever has been. So it's kind of hard to get like into the details. And then, of course, because of the sort of crazy political era that we live in, depending on, what color your card is, even up on Capitol Hill in Congress, there's hearings happening about this and certain personalities jumping up and down about, regulations getting pulled back and whatnot. And even that seems to be just full of hyperbolic, inaccurate nonsense. So you can't even look at that as a source of information. So what I did, and I would encourage other people to do, is to actually go and read the opinion. Because it's pretty interesting, actually.
Yeah, it's pretty readable, too.
Yeah, I agree. It is pretty readable. It's not a whole bunch of legalese.
Not really, yeah.
And you read the opinion, at least I speak from my own personal experience, you read the opinion and you're like, well, yeah.
Yeah, I know. I've had that. Yeah.
So
that always happens when you read those Supreme Court decisions. It's like, that makes sense.
Yeah.
Even when you don't agree with them, it's like, yeah, it kind of makes sense.
Yeah. And in this particular circumstance, there's downstream consequence for sure. And because, we've sort of been living in this space, even though maybe we haven't been living in the space for the last 8 years that you mentioned at the beginning of the pod here, but basically what they're saying, again, not a lawyer, but basically what they're saying is that there's a due process problem under the Chevron doctrine. It says, our expectation as Americans, right, is that if you get accused by somebody of doing something illegal or criminal, right, you have the right to get tried by a jury of your peers and for somebody to make a decision about your guilt or innocence. And what has happened under the Chevron doctrine is that has been usurped by agencies where they are both the judge, the jury, and the executioner, to use an old world phrase. And that's just sort of antithetical to the sort of constitutional order of the United States of America and violates apparently the 14th Amendment, due process clause.
The APA put in place in 46 to kind of like rein in agencies too.
Yeah.
And it was a really interesting point in the decision. I think it was in decision, maybe it was in Justice Roberts' opinion, but they made the point that because the legal tests starts and ends with, is the statute interpretation by the agency reasonable?
Yeah.
That then you defer to them. So a reasonable one gets put in, even if the court can come up with a better explanation themselves. They don't get to that step.
Yeah.
Because Chevron would say, okay, that's reasonable. You can have it.
Right.
We think we got a better idea, but we don't get to say that, even though we're the courts and we're the ones who presumably get to say what the law means.
Right. So, yeah, you get due process issues, you get separation of powers issues. Just for people who are not at all familiar with the law, we're talking about the executive branch basically taking on some of the role of the judicial branch, which is what you were just talking about. And that's not, air quotes, supposed to happen. So, I think if you read the opinion, you may walk away with the sense that this reversal is going to create this clog in the courts because all of a sudden things that agencies had just been sort of judge, jury, and executioner on their own is now going to have to go to court where there's a dispute. And, I'm assuming that there's probably some truth to that. And when you're talking about the federal government at large, it's almost impossible, I think, to sort of even speculate like how many different sort of dark corners that this may transition into because the government is so omnipresent in so many ways, from the delivery of the mail to approval of drugs to, establishing, what the grade of gasoline is that you're putting in your car, it's literally everywhere. So, I think it's almost impossible to sort of really predict, like where legally this kind of ends up from a test perspective. But having said all of that, some of the arguments against overturning the Chevron doctrine are issues of practicality. That's kind of like how I interpret it. They're like, well, maybe the constitutional argument is correct, but this is going to create a mess. I think everybody's entitled to their own opinion, how they feel about that.
Because the other side would say Chevron has created a massive mess.
Yeah.
They'll tell you that in cases where there shouldn't really be ambiguity about Congress's intent, somehow ambiguity is still being found. That came up specifically in the Loper case where, as we say earlier in the pod, both sides seem to agree on what Congress's intent was, which should end the test there. But yet lower courts were still finding ambiguity in a proceeding as if it was a Chevron case.
Yeah.
Then you've also got the problem that it's not that once the agency says this is what the ambiguous text means in the statute, then it's settled. It can continue to change.
Yeah.
So a new administration comes in and they decide to interpret the statute in a different way than the last administration does.
Right.
And so you have completely unsettled statutes.
Right. And that creates its own chaos, as you mentioned. Yeah. Our CFO, Joe Cardinale, and I are both giant football fans. Football with a F-U-T. And we talk about the offsides rule in soccer all the time. And the technology that they, it used to be there's a guy running up and down the sideline and he had to sort of visually gauge and would raise a flag for offsides. And, okay, great. But as we've evolved technologically, we've gotten to the point now where they have like cameras and, chips in the ball and they can measure this stuff down to like these very tiny fractions. And there's a lot of people who are very upset about that because they're like, well, it sort of takes away from the flow or the essence of the game. But in that particular instance, and this is kind of what we argue about because he's on that side, I'm like, no, it's black and white. Like the offsides rule is not interpretive. You either are offsides or you are not, right? Mm-hmm. And our ability to now measure that more finely because it's not based upon, an individual running up and down the sideline and trying to make a judgment with their eyeballs at some distance. And, there's other people in the way and all that sort of stuff. But now we have, lasers and whatever that can measure it like right down to like literally fractions of an inch.
Yeah.
Okay. Sometimes people were getting called offsides historically that shouldn't have been, and were getting called onsides that shouldn't have been, and vice versa. And now that happens less and less. I think that's a good thing. It's a black and white rule.
Yeah.
And in this particular case, even though, the permutations may create some kerfuffles in terms of loading the court systems with tests and whatnot, I kind of fall on the constitutional side of this personally.
Yeah.
It's kind of black and white, right? Like the document was sort of, separation of powers.
Mm-hmm.
There's a reason for that. And, we've kind of made a mess out of that in this particular space. And so, they're trying to correct that mistake. If correcting the mistake creates, conflict and whatnot, chokes the courts, conflict's not the right word, but legal tests, right?
Yeah.
Well, where's that old saying, it's always easier to do it right the first time than have to do it twice.
Yeah.
There's some truth in that. And I think that's kind of where we are. We're kind of doing, by proxy here, we're kind of doing this twice, but I don't think that the efficiency arguments kind of really work out, right?
Yeah.
It's to me at least, to use some, sort of legal language here, that's the proverbial slippery slope, right? You either read the document and understand what the intent was and you live by those rules, or you try to change them, due process, or you don't.
Yes.
And it's kind of, for me, it's kind of black and white.
Mm-hmm. And for people on maybe one particular side of the aisle or the other who may be feeling some anxiety about this, it's funny to remember that one of the early champions of Chevron was Justice Scalia, who thought it was great because it was a huge win for industry when it was first put in place. Now that's flipped because it's become a huge win for the administrative state.
Yeah.
And now that it's gone away, there's this whole other conversation of like, oh, we've actually just really weakened the executive branch. The presidential, powers that have been accumulating for decades took a little bit of a hit for once.
Yes.
And it's like, you may feel you're on one side of the issue here, but it can kind of change depending on where you are, because this really is about the powers of the administrative state.
100%. Yeah, it's kind of fascinating. And again, kind of back to what I was saying before, I think that, the current state of news media and I don't mean to blame, Fox News versus MSNBC or whatever. They're all in it in the same way.
Yeah.
But the quality of information that you get is just not great.
No.
And frankly, to be blunt about it, I think it's just a reflection of us, the TikTok society. Everybody wants things in less than 30-second bits.
Mm-hmm.
But these kinds of things are not given to 30-second bits. They require a little bit more knowledge and reflection.
Mm-hmm.
And so I think media is just kind of giving us what we're asking for. But unfortunately, it's led to like a lot of, I think, really deep misunderstandings of what this is all about. I don't personally see this as actually a left or a right issue. I think this is actually the tension between, the executive branch and the judicial branch that is supposed to exist by design in our constitutional republic. Yeah. And so in a way, I think the system is working here, whether you agree or you disagree with the Chevron doctrine. And I would just encourage people to try to step back in these sorts of issues and look at them more holistically. I'm reminded that I think might have been just about a year ago, there was a decision that came out of the Supreme Court right after Ketanji Brown Jackson got on the court. It was a EPA wetlands case where there was this, again, not pulling the details out of my memory here, but a private property owner, I think in Colorado, that was trying to develop a piece of property, and it had this vernal pool on it, and EPA came in and said you can't build there, and turned into this huge thing, and it was like this long lawsuit and whatever, and finally got to the Supreme Court, and the Supreme Court ruled in favor of the property owner. And I don't remember the details specifically of the ruling, but basically what they were saying is that the EPA sort of exceeded their statutory authority for this series of reasons. And immediately on sort of the liberal side, there was this outcry about how the Supreme Court was weakening the protections for wetlands. And, for those of us who are environmentally conscious and live in this space, you're like, oh my God, that's really terrible, right? And then like the first thing that rattled me about that and made me stop and take a pause was that decision was a 9-0 decision.
Yeah.
9-0.
Mm-hmm.
So that's not a liberal versus conservative. Everybody agreed EPA had exceeded their statutory authority in this case.
Yeah.
I don't know. I think that's kind of important to recognize, right? And I feel like you don't get that a lot in opinion-based news media. You don't get that sort of reflection. Yeah. So totally off the subject, but I just think the same thing sort of applies a little bit here with the Chevron doctrine. I think if you read the opinion, as we've already stated, but if you read the opinion, you'll read it as you and I both did separately, and you're like, well, yeah, I get this, right?
Yeah.
I understand how they got here and why they got here, and it makes sense.
Mm-hmm.
And if the fallout is that there's some chugging through the court systems to make some determinations that heretofore under the Chevron doctrine we didn't have to work through, well, that's the process. At the end of the day, I don't think that it's going to roll back health protections, or it's going to roll back environmental protections, or, corporations are now just going to be able to go back to using asbestos all the time. And like, I don't think that that's what the point of this was. And I don't think that that's what the Supreme Court was looking to make happen. I don't see it.
I know, as not a lawyer, I don't know how this has effects how existing law or statutes can be challenged.
Yeah.
I know that nothing is being overturned
Yeah.
as a result of this decision, that those decisions stay in place even though they rely on Chevron. But it feels like it's just a change in how you're going to have to go forward.
Yeah.
And I think that's kind of the takeaway that I would want to leave people here is that if your concern is that decisions are not going to be science-based, and I would love to know how many of the 17,000 cases decided on Chevron were about issues of science, because like the Loper decision is based on overcharging fishing vessels. It's not really a science question.
Right.
If you're concerned about science, these rulings are going to be decided on the law that's passed from now on rather than deference. So it's the legislation needs to be science-based.
Yeah.
And the people you choose to elect need to be people who make science-based legislation. And that probably should have been the thing from the start.
That's a great point.
Yeah.
It really is. And I'm glad you brought up that it's about fishing vessels, because I'm not even sure most people realize that.
Yeah.
You know, Chevron, because they're talking about Chevron Oil Company, right?
Mm-hmm.
Like that's kind of the history of this, right? But like in this particular challenge, right? Again, everybody should read the opinion and understand the case. But like if you read the plight of these fishermen and what was happening, it's very hard, even in the context of species preservation and trying not, you know, to prevent overfishing, which is the goal here, and that's an important goal. But you can't help but look at it from the fisherman's perspective and be like, excuse my French, that's kind of shitty. Like it's a lot. It's a lot.
Mm-hmm.
Yeah.
Yeah, we talk about it in the work hard section, but the charges for those fishing vessels were supposed to be 2 to 3% of the value of the catch of the vessel, and they were looking at costs in excess of like 20%.
Right.
And it's like it's not workable.
It's not workable. No. Yeah, it's crazy.
Yeah.
We're living in crazy times, Tom.
We do.
Thank God we have beer.
Yes, absolutely. Well, I think that'll wrap it for us. Thank you so much, folks, for joining us on this episode of 312, the HRP Podcast. If you are listening out there, rate us 5 stars on whatever your podcasting platform is. That's kind of an Apple thing. But if you're watching us, hey, thanks for being here. Give us a thumbs up, subscribe, and hit the bell for notifications, and we'll see you next time.
Thanks, everybody.
Thanks, everybody. Bye.